the Supreme Court arrived at a jurisprudentially correct decision. But it has damaged parties who were in that court, in that decision, and the larger Muslim community. And there was a way out under the Islamic Sharia if an opportunity was given to the Qadi. It is not in the place of a party who is seeking inheritance under the Islamic law to question another party. For example, FAA could not question whether the children of the other two mothers were born in this way or not born in this way. It's not her place. Islamic law says, if these children were born, how do you resolve these issues? Islamic law on Sharia is based on two things, inheritance. It is based on marriage and blood relationship, what they call consanguinity. There is nobody who has contested during the lifetime of the deceased that these children were not his. So the question of whether they were this way or that way, because I don't like the usage of that name, because that is a dent that will follow those children to the rest of their life. If that matter was given to the Qadis, that issue would not have arisen, and they will have come to the same conclusion. The point I'm making is the courts should give an opportunity to the Qadis court within the sanctioned constitutional boundaries of fairness and in compliance with Article 24(4), that there should be no injustice to the children or to anybody who is entitled to inherit from the estate of the deceased person. My view is the methodology was wrong from the High Court, because if you see the judgment of the judge of the High Court, he ordered for a DNA, which was not applied by any of the parties. The parties were questioning their status. One was questioning, this one is not married. This one was married. Even the appellant, her status in the inheritance was questioned by the other parties, and there was evidence which the judge discounted, rightly or wrongly, I don't know, that she should not inherit. So the question I'm putting is, don't constitutionalize Islamic Sharia, but allow the constitutionalization of Islamic Sharia to function within the parameters of the four corners of the laws on inheritance. That is, they must observe equality, they must observe fairness, and they must not, the decision must not go outside or in violation of the right of the children and the right of the parties who are entitled to inheritance. My view, therefore, is the court reached the correct decision jurisprudentially, but the methodology was wrong. Islamic law is not an ordinary set of rules or set of cultural rules. You cannot say, for example, Islamic law is repugnant to justice. The culture of, for example, a Muslim who is a Somali or a Kikuyu can be said, his culture, not Islamic Sharia, is repugnant to justice. Because Islamic Sharia provides for all scenarios. And it says any interpretation that results in operation or harm or injury to the parties before court is not part of the religion.